Good evening, friends. As you all know that Bharatiya Nagrik Suraksha Sanhita 2023, in short BNSS, is going to replace the existing Code of Criminal Procedure 1973, that is CRPC, as it has been notified to be implemented from 1st July 2024. So, what will be the situation after 1st July 2024? I am going to discuss along with the provisions what has been new one and what has been changed, what are the effects, positive as well as cause for concern. While some provisions in the BNSS, just as focus on the use of technology during investigations, trials, and further provisions for definite time frame for various legal procedures are a good step and are a step in the right direction, which would lead to greater transparency and efficiency in the criminal process. But some other altered provisions also are a cause of concern, such as expanding police powers. This is a cause of concern. So, notable changes which the CRPC has gone and will be seen in the BNSS, I am going to discuss about them. Firstly, expansion of police powers. As you know, the BNSS expands the limit of the police custody under general criminal law and provides that the judicial magistrate may give police custody for a term not exceeding 15 days in the whole or in parts at any time during the initial 40 days or 60 days out of the maximum detention period of 60 days for offences punishable with imprisonment for less than 10 years or 90 days for offences punishable with death or imprisonment for life or imprisonment for a term of not less than 10 years. So this gives our general criminal law the same flavor as some of the special laws with stringent custodian conditions. Next is discretionary registration of FIR. The Bharatiya Nagrik Suraksha Sanhita provides that on receipt of information relating to cognizable offense punishable with imprisonment between 3 years and 7 years, the officer in charge of the police station may, with the prior permission of his senior officer, proceed to conduct a preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter, that is within a period of 14 days. This seems to contradict the direction of the Honorable Supreme Court in Lalita Kumari versus Government of Uttar Pradesh, which mandated the police to record information of a cognizable offense as FIR and investigate the offense regardless of what the police felt about the credibility of the information. So there is somewhat little discretionary power with the police officer for registration of FIR. Now, third provision is handcuffing. The BNSS contradicts the Honorable Supreme Court directions that were in Sunil Batra versus Delhi administration and Prem Shankar Shukla versus Delhi administration. Formally brings back the uses of handcuffs. Section 43 of the BNSS, dealing with the manner in which an arrest is to be made, provide the police with discretionary powers to handcuff accused person for serious offences, including but not on limited to, including rape, acid attack, murder, sexual offences against children, drug-related crimes, and so many others. So this section provides that a police officer may, keeping in view the nature and gravity of the offense, use handcuffs while making the arrest of the person or while producing such person before the court who is a habitual or repeat offender or who escapes from the custody or who has committed offenses of organized crime or terrorist act or drug related crime or illegal possession of arms and ammunition, murder, rape, acid attack, counterfeiting of coin, currency notes, human trafficking, sexual offenses against children, or offenses against the state. And third one is the emphasis on use of technology during investigation and trial. The BNSS mandates the recording of search and seizure procedures through audio, video, electronic means. Witness statements, confessions, appearances can be also be recorded by audio, video, electronic means. Now, another one is forensic science in investigation of crime. BNSS mandates forensic investigation for offenses punishable with 7 years of imprisonment or more. The forensic expert will visit the crime scene to collect forensic evidence and also cause videography of the process on mobile phone or any other electronic device. This is again a positive step for technology during investigations. Although success of this initiative would largely depend on the adequacy or development of forensic infrastructure, including that of training. So this subsection will come into force within a period of 5 years of the passing of the BNSS as notified by the state government. Then there is further change of biometrics. The BNSS expands the scope of biometrics and provides that any person can be ordered by the magistrate to give specimen signatures, finger impressions, handwriting, voice samples in connection with an investigation or proceeding, even if he or she is not an accused person. Further, going to zero FIR. The BNSS provides for zero FIR and states that an information relating to the commission of a cognizable offense, irrespective of the area where the offense is committed, may be given orally or by electronic communication to the officer in charge of the police station. Thus, this provision states that registration of FIR can be done by electronic means also. Further, there are literal changes in the provision of bail. The BNSS addresses the maximum period for which an under trial prisoner can be detained and states that an under trial accused of a crime carrying a life sentence is not eligible for release based on their incarnation term. Previously, only under trials accused of a crime carrying a death sentence were not eligible for release based on their incarnation term. Additionally, the BNSS states that when an investigation, inquiry, or trial in more than one offense or multiple cases are pending against a person, he shall not be released on bail by the court. This can prove to be extremely burdensome for accused persons undergoing investigation or trial, as in lot of cases, an accused is charged under multiple offenses. Then there is anticipatory bail. The BNSS deletes the guiding factor which the court's hearing anticipatory bail application may have taken into account such as nature and gravity of the acquisition, criminal antecedents, and possibility of the accused to free flee from justice. This deletion widens the discretionary power of the court hearing such applications. Further, the bnss also deletes the proviso requiring the presence of the applicant seeking anticipatory bail at the time of filing hearing of the application and passing of final order by the court. Now, coming to timelines. The BNSS attempts to lay a foundation for speedy justice by providing timelines for different processes in investigation and trials. As far as investigation is concerned, for offenses punishable with 3 years or more, what less than 7 years, the officer in charge may, with the prior permission of the Deputy Superintendent of Police, proceed to conduct a preliminary inquiry within 40 days, 14 days to ascertain if there exists a prima facie case and proceed with the investigation. Where there exists one. The police are now under an obligation to inform the victim or informant of the progress of the investigation, including by electronic communication within 90 days. Further investigation shall be completed within 90 days, which may be extended with the permission of the court. Now, committal. When in a case instituted, the accused appears or is brought before the magistrate, and it appears to the magistrate that the offence is trialable exclusively by the court of session. He shall, the word is shall, he shall commit the case within a period of 90 days from the date of taking cognizance, and such period may be extended for a period not exceeding 180 days for reason to be recorded in writing. Supply of police reports and documents. Where the proceeding has been instituted on a police report, the magistrate within 14 days from the date of production or appearance of the accused supply to the accused and the victim a copy of police report and other documents. Now coming to discharge of accused. The accused may prefer an application for discharge within 60 days from the date of supply of copy of the documents. So he is given 60-day time to study the documents and then take the action as is his desire. Framing of charges. Trial before a court of session. Charges will be framed in writing against the accused within 13 days from the date of first hearing on charge. Now coming to judgment. After hearing arguments, the judge shall give a judgment within 30 days from the date of completion of arguments, which may be extended to 45 days for reason to be recorded in writing. Now, adjournments. In every inquiry or trial, the proceedings will continue daily until all the witnesses in attendance have been examined. Unless the court adjourns, no more than 2 adjournments will be granted. Cases instituted on a complaint. Presence of complainant. Previously, the CRP provided that when proceedings have been instituted on a complaint and the offences alleged are either compoundable or are non-cognizable, the accused would be discharged when a complainant remains absent on any day fixed for hearing of the case. Now altering the same provision, BNSS now provides a grace period extending to 30 days, which may be provided to the complainant to remain present before the requisite court. Now, opportunity of being heard to accused. The magistrate now must provide the accused person with an opportunity of being heard at a pre-cognizant stage prior to issuance of process. This right was not provided to the accused at the pre-cognizant stage in the CRPC. Now, dealing with proclaimed offender, expansion of definition of proclaimed offender. Now, as per CRPC, a person could be declared a proclaimed offender only for specified offences, which led to situations wherein persons could repeatedly evade legal process of brunt summon for offences other than the specified. Now, the BNSS has altered this provision and provides that anyone accused of an offence with more than 10 years imprisonment could be declared a proclaimed offender. The BNSS also provides more detailed procedures for investigation outside India and for forfeiture of property of proclaimed offenders staying abroad. Now, there is provision for trial in absentia for proclaimed offenders. The BNSS provides that when a person declared as a proclaimed offender and has absconded to await trial and there is no immediate prospect of arresting him or it shall be deemed to operate as a waiver of the right of such person to be present and tried in person. And the court shall, after recording reasons in writing, proceed with the trial in the manner as if the absconder was present and pronounce the judgment. The Eastwhile CRPC only provided for recording of evidence in the absence of the accused in some cases only. Now, clarity on reporting obligation. The law makes it clear that no reporting to authorities is required in cases of corruption and other economic offenses unless they form part of organized crime, which includes economic offenses and cybercrime offenses. Even in cases where reporting is mandatory, there is an exception for reasonable excuse, the burden of proving which excuse shall lie upon the person so aware. Clarity of role of director of prosecution. The legislation throws light on the role of director of prosecution, which will be to monitor cases in which offences are punishable for 10 years or more, to expedite the proceedings, and to give an opinion on filing of appeal. This shows that director of prosecution may get to decide on appeals independently, irrespective of police or prosecution recommendations. Now coming to witness protection scheme. Under the BNSS, state governments have the authority to notify witness protection scheme. The provision regarding witness protection scheme was not there in the CRPC. Then attachment, forfeiture, or restoration of property, which is proceeds of crime. The BNSS introduces a provision for the attachment, forfeiture, and restoration of property, which is derived or obtained directly or indirectly as a result of criminal activity or proceeds of crime. The word proceeds of crime, as defined in section 111 of the BNSS, is similar to the definition of the term under the Prevention of Money Laundering Act 2002. Thank you. Thank you for watching. See you again. God bless you all.